So when a disproportionate percentage of the people who law enforcement agents or police target are people of color, when we learn that that is happening with a particular type of law enforcement operation, we can file discovery motions, we can file motions to dismiss, and we can support those motions with empirical data and expert testimony. Given everything that Rasan just said, now more than ever before, we just have to stand up and fight for our clients when law enforcement agencies or prosecutors discriminate on the basis of race. So in Chicago right now, my federal criminal justice clinic at the University of Chicago Law School has joined forces with other lawyers who represent indigent clients, federal public defenders, CJA panel lawyers, and we're going after the ATF for race discrimination, and expert testimony is at the heart of our challenge. So I want to talk to you a bit about what we're doing with the idea that this can be a kind of model for other people to litigate these same kinds of issues, because we've been having a lot of success. This starts with the ATF. The ATF has been creating crimes for decades. And then they've been selecting people of color to commit these totally made-up crimes. So the way this works is an ATF CI, a confidential informant, approaches a person of color who's down on his luck and proposes that they rob a drug stash house together. When the target, the person agrees, then the CI brings in an ATF agent. And this ATF agent says, now be sure to bring a bunch of friends and bring your guns and have your friends bring all their guns too. Because this house is just going to be heavily guarded and there's so much drugs in there and we're just going to make a killing. So it turns out the whole thing is totally made up. There's no house, there's no drugs, there's no guards, totally a fiction. But federal prosecutors around the country for years and years have been bringing very real federal drug, gun, and robbery charges against these clients. And all of this, for attempting to rob a wholly fictional quantity of non-existent drugs from a non-existent place. This fake crime typically carries mandatory minimum penalties. The minimum is 15 to 25 years in prison, and there are many people all around the country serving life in prison right now for this made-up crime. These cases, I call these fake stash house robbery cases, so I'm going to refer to this as stash house litigation. The most disturbing thing about stash house cases is that the vast majority of people who the ATF select to commit this fake crime are people of color. So nationwide, there was a study that showed 91% of these folks are people of color. In Chicago, 94 people have been charged with this crime in the past decade, and the race breakdown is just as bad as it is nationally, right? It's 92% people of color. Of those 94 people charged in Chicago, 43 clients are still pending trial in federal district court. Those 43 clients are spread across 12 separate federal criminal cases, which are in front of 9 of our judges in the federal courthouse in Chicago right now. And my clinic has organized all of the lawyers and all of the clients and all of the cases so that we are pursuing a coordinated litigation strategy. I call this a criminal class action. We are alleging that the ATF has engaged in selective law enforcement in violation of the constitutional right to equal protection. Our ultimate goal is to convince the judges to dismiss all these cases against the 43 clients. So to reach that goal, we decided that we would need an expert witness who could conduct an empirical analysis for race discrimination, to show race discrimination of the sort of thing that Rasan was just talking about. So what we did was we litigated and won a motion for expert services, since we're poverty lawyers and our clients are all indigent, and we agreed that we would use a single expert, one expert for all 43 clients. And with so many clients, the court gave us a lot more money, right, than they would ever given to just one individual client. And this is my idea of their strength in numbers. There really is. By joining forces, we were able to hire a nationally recognized expert on race disparities in policing. Our expert is actually one of the very same experts Rasan used, Professor Jeff Fagan at Columbia Law School. He was the plaintiff's expert in the very successful New York stop and frisk litigation where they proved race discrimination by the NYPD. So at this point, as we stand here today, we have now filed 12 of these motions to dismiss. I call it defendant's motion to dismiss for racially selective law enforcement, because we start our argument right at the beginning, right? We've got 12 of these pending right now. You have links to this motion in your materials. They're pretty unusual motions. Each one's about 70 pages long, supported by hundreds of pages of exhibits. And the key exhibit is this report by Professor Fagan, which finds statistical evidence of race discrimination by the ATF. And this litigation, I mean, it's far from over, but simply litigating these issues in a coordinated way is already bringing about a lot of change. So that's part of what I want to talk about here today. I mean, the fight alone, this is my strength in numbers slide, right? The fight alone has changed judges' perspectives. It's changed prosecutors' policies in our U.S. Attorney's Office. It's changed the law, as I'll tell you about, and it's resulted in some really significant victories for our clients. Our litigations also captured the attention of the press and the public. So the Chicago Tribune, our main newspaper, recently published a front page above the fold story about our cases and our clients. It was very sympathetic to our clients. This is in your materials. And when we first filed our motions to dismiss, it made national news. USA Today called our litigation an unusually broad challenge to federal law enforcement tactics. I know it's USA Today, but still, this guy who writes for it, he's a lawyer. He went to Georgetown Law School. He's brilliant and awesome, and he cares about this stuff. Anyway, this kind of press can really generate change. My materials provide kind of a step-by-step process for this kind of selective enforcement litigation. So what I want to do here is just kind of hit some of the key steps, not go into too much depth. But there are really two stages to the litigation, okay? The first is discovery, and then the second stage is this motion to dismiss the indictment for selective law enforcement or selective prosecution. The same standard applies. But, the problem we always face in these situations is this catch-22, where in order to get the discovery necessary to prevail on the motion to dismiss, we have to prove a certain amount of race discrimination already, okay? This problem was created by the Supreme Court in this awful case called Armstrong about 20 years ago. And in the 20 years since Armstrong, selective law enforcement, selective prosecution challenges have been pretty much a dead letter. To get discovery or to get a motion to dismiss granted, it's basically similar standard, okay? We've got to prove two things, right? We have to first show that the law enforcement or prosecution policy had a discriminatory effect, and then secondly, it was motivated by discriminatory purpose or intent, okay? So to demonstrate effect, and this is the real kicker, Armstrong requires us to show that similarly situated defendants of other races could have been prosecuted but were not, okay? And so what that means in a selective law enforcement case, it's even harder, right? Because we have to show there were similarly situated white people, like in my case, similarly situated white people available to be targeted by the ATF who the ATF did not go after, okay? And so that sounds really hard, or who they didn't go after to the same degree as people of color. But I'm gonna tell you how we did this. But the problem is with this, like that stark race disparity that I told you about, that alone, 92% people of color, that is not enough to even meet the standard for the discriminatory effect prong, the first prong. So we're really up against a hard standard, and no court has ever dismissed a case on these grounds since Armstrong, since before Armstrong in '96. So to meet the similarly situated standard with a statistical analysis, this is the kind of way I lay out how we do this. We've got to obtain data about the racial composition of two groups of people, okay? The first group I talk about is like the defendant group, right? Who are the people who were subjected to this discriminatory law enforcement tactic? And so the defendant group in our cases, in the Stash House context, that's the 94 defendants who've been charged since 2006. The second group this is the similarly situated comparison group, right? This is defined by the ATF's targeting criteria, as I'll explain in a minute under the case law. But what you want to do is figure out who's in that group, and ideally you want to figure out in the same geographic area during the same time period, okay? Have those parallels for this. And I'm going to talk about how do we gather the data about who is in these two groups. So the first step in this kind of litigation is to get as much evidence as possible about the defendant group, okay, before we even request discovery. This is one of the keys to all of this. We need information about all the defendants in the district or the county who've ever been charged in this type of case or this type of operation that we're going after. So in Chicago, it was as simple as just, I mean, it wasn't that simple. It wasn't simple at all, but started with like an email that gets sent to all the federal defenders and all the federal criminal defense lawyers in the district saying, have you ever had a stash house case? And then following up with phone calls. But the point of all this is you want to figure out what are the case numbers, what are the client names, and most importantly, because this isn't going to be on, Pacer or in the electronic file or in any file, what is the race of each and every one of the clients who's ever been targeted for this operation, okay? And by doing this, we figured out this stark race disparity that I talked about, the 92% are people of color. So that's how we discovered it. Once you have evidence of this kind of disparity, that's when you join forces with everybody who's still got a pending pretrial case, and you go to the court to get an expert. You say, we've got some evidence here that's very disturbing and troubling. We need an expert witness to help us go further with this, given the standard. I mean, part of how we got the expert was to say, look what Armstrong requires. We got to have an expert here. No one's proved it. We got to give us something more. So anyway, the third step after you do this and you get the expert, really the third step is requesting discovery, filing discovery motions. And my experience is that if you make this good faith effort to figure out who's in that defendant group on your own before you go to the judge and ask for discovery, you've got a much better chance of getting discovery. And that's what happened in our Chicago cases. So one judge issued this order. He found the showing was substantial enough to require the government to provide discovery on the subjects of a list by case name, number, and race of each defendant of all phony stash house ripoff cases brought, isn't that great language? Brought by the U.S. Attorney's Office in this district from 2006 to the present. So we had a lot of information, but we didn't know if it was right? We had to confirm who is really in that group. And this was essential to that. This order's in your materials, as are other orders from our cases. So this coalition of lawyers in Chicago eventually surmounted Armstrong's very high bar, and we won selective law enforcement discovery in 7 of our cases. And an essential aspect of the discovery that the judges ordered were the ATF's manuals, okay? Those manuals have targeting criteria and internal requirements for the stash house operations. So this is part of the same order. The judge ordered us to get any document prepared by ATF which summarizes how to investigate and prosecute phony stash house ripoff cases, including any guidelines that they follow, okay? So these manuals, we got the manuals. They're still under seal, but our motion and expert report are totally public record, and these manuals are cited and quoted throughout. And we got the judge, originally the prosecutors were insisting we file it under seal. We ultimately that reporter from USA Today went to the judge, filed his own kind of motion and said, you can't put this under seal, First Amendment. And so the judge unsealed everything except for these manuals. The motion's unsealed, the expert report's unsealed, the manuals are still under seal, but they're quoted, it's quoted throughout. So at this point, anyone else who wanted to litigate this doesn't need discovery necessarily to get this, because you can learn a lot, basically everything you need to know from the public information that we've got out there. Okay, so the fourth step is got to figure out who's in that other group. What is the racial composition of this similarly situated comparison group, this ephemeral concept, right? This thing on the right side of my chart, okay? Who the heck is in this group? And as I said, under the legal standard, that group is defined by ATF's purportedly race-neutral targeting criteria. So what did we learn from the discovery? We learned that ATF purports to go after people who have prior convictions for guns, robbery, and other violent crimes and drugs, okay? So we subpoenaed criminal history data to determine what is the entire universe of people within our relevant 9-county geographic area where the ATF was prosecuting these cases, from 2006 to the present, who has these prior convictions. And after 9 months of battling over our subpoena and doing this ridiculous civil litigation that I've never done before because I'm a criminal offense lawyer, I eventually get, the judge orders the repository of all this criminal history data, who happens to be the Illinois State Police, to give me a huge amount of stuff, okay? Criminal history records for every person convicted of any of the offenses listed below, and it's like a page-and-a-half long of criminal statutes committed in one of the counties below from 2000 to 2015, and everybody's race, okay? So I get this, and these records show that there are almost 300,000 people with convictions for the offenses that ATF claimed they were targeting. Ultimately, this took basically a full year of litigation just to get the data upon which my expert needed in order to begin his statistical analysis, okay? So, let me tell you about what our statistical argument is in our motion. A central aspect of our motion is this expert report, the Fagan report, prepared by Professor Fagan. And the idea is this provides the evidence of discriminatory effect that was missing from Armstrong and that's been missing from other cases that have not prevailed. So what Professor Fagan shows is that similarly situated white people were not targeted to the same degree as people of color. And I have a chart in the motion to kind of illustrate this idea of what he gets at, okay? Sorry, this is a little bit small, but let me explain. Look at the figure 1 on the left side, okay? This is our stash house cases, and I'm showing here what is our comparative evidence that we've established. So, looking at the defendant group first on the far left side, those are our 94 defendants. The racial composition of this group is 78.7% black, okay? That's really important, okay? And then if you look at the similarly situated comparison group, the very next column over, the racial composition is 55.4% black. And what Professor Fagan finds is that there is an approximately 0% likelihood that the ATF could get that disparate racial composition just by chance, okay? Which is very, very, very powerful. And then, wait, one more thing on this chart. If you look at on the right side, Armstrong has no comparative evidence. There's none of this evidence of who is in the similarly situated comparison group, so we can't figure out what is the likely chance that they would get that group, what is the likelihood they get that group by chance. So we have proof that was not provided in Armstrong. And the Fagan report, so that's discriminatory effect, okay? That's just prong 1. Then we have to prove discriminatory intent, which is even harder. But it's our position that the Fagan report also provides significant evidence of discriminatory intent. Because this is a deep simplification, but what Professor Fagan does is he conducts these 3 complicated regression analyses, and he rules out race-neutral explanations for this disparity. And he controls for demographic variables, he controls for criminal history and criminal propensity and all sorts of things, 17 different variables he controls for, and he comes to this conclusion that the stark racial disparity cannot be explained on grounds other than race. He says these analyses show that the ATF is discriminating on the basis of race in selecting stash house defendants. So that is central to our motion. Beyond the Fagan report, we have additional evidence that the ATF was intentionally selecting its targets on the basis of race. So we also include in our motion this chart, which you don't have to know what anything here says. All I want you to look at is the red, okay? And let me tell you what this does. This shows that the ATF was departing from its internal criteria whenever it targeted people of color, okay? The red blocks indicate all the deviations from their internal targeting criteria, okay? And as you see, this entire group, I'll just tell you, everybody in this group is black, okay? Now, in the few instances where the ATF went after white people, they scrupulously followed their criteria, okay? You see the stark difference between this and this, just the red? These are the cases involving white people. Yes, 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 yes. Check every box. We do it right there. But here, we deviate from our criteria. Well, These kinds of racially skewed departures from procedural and substantive criteria are evidence of discriminatory intent under Supreme Court law, under Arlington Heights. So that's another major point in our motion. And that involves a lot of deep factual analysis of the cases from getting the discovery that we got. So we also, I don't have time to get into this, but we provided evidence that in some of the cases, the ATF agents expressly recruited black people on the basis of race. I'm not going to get into it now, but it's in the materials, and basically it was crazy. So the government then files this response. They file a 120-page response to our motion to dismiss in all the cases, with a responsive report from their expert that tries to tear down what Professor Fagan did. And over the last 3 weeks now, because I said I'm very much in the middle of this, I filed 12 separate 60 to 70 page reply briefs in these cases. And fully 7 of those were due on Monday. And I got them filed right before midnight, so it's been a hard time. But anyway, here we are, and we have this unbelievable, phenomenal 50-page reply report from Professor Fagan tearing down everything the expert of the government tried to do, okay? So that's fantastic. We're very excited about this. And so the next step is really cool, okay? The next step, the 9 federal district court judges in these cases are doing something totally unprecedented that makes this even more of like a criminal class action. I've convinced them to clear their schedules for 2 full days to hold a joint evidentiary hearing in all 12 cases, okay? So they're gonna hear all the same testimony, all the same evidence. It's gonna be like a battle of the experts between Fagan and the government's guy. And it'll be kind of almost like an en banc, Court of Appeals oral argument or something, but in front of 9 trial judges, each of whom gets to make their own decision ultimately on the motion to dismiss. And then we'll wait for rulings on the motion. So we're still very much in the midst of this litigation, but before I finish, I just want to tell you some of the real victories that we've had along the way. First, we survived a prosecution appeal of one of our discovery motions, and we convinced the Court of Appeals to relax the Armstrong standard. This is very exciting. I ended up litigating this case en banc, and the Seventh Circuit became the only Court of Appeals, the first at that time, since Armstrong, to authorize discovery of selective enforcement discovery. And they really, of selective enforcement materials, they created new law. It's very exciting. In brief, this is from a pretty conservative court. They said the racial disproportion in stash house prosecutions remains troubling and is a legitimate reason for discovery. The best thing about this Davis case is this distinction it draws between discovery about prosecutors' practices and discovery about law enforcement practices. It really distinguishes Armstrong, okay? And this distinction is totally crucial. So what the court says is the sorts of considerations that led to the outcome in Armstrong do not apply to contention that agents of the FBI or ATF engaged in racial discrimination, okay? So that is really exciting, and that is an amazing kind of advance in the law. And then just a few weeks ago, the Third Circuit relied really heavily on our Davis case and took the distinction even further. In fact, this was another selective enforcement case, also stash house case. The Third Circuit eliminated 2 of the Armstrong requirements for discovery purposes, okay? They entirely got rid of the discriminatory intent requirement, and then they also eliminated that similarly situated requirement for the effect prong. So just to read you, it says, this is different from Armstrong. A defendant need not, at the initial stage, provide some evidence of discriminatory intent. This is unbelievable, right? Or show that on the effect prong, similarly situated persons of a different race were not arrested or investigated by law enforcement. This is like a total revelation. And they rely very heavily on my Davis case. And it was one of the most exciting things I've ever seen, because thanks to these cases, the discovery standard now for these issues is better than it's ever been in our lives. So that's cool. And there's other cool things. So in the face of our litigation, our U.S. Attorney's Office has totally changed course. They've done 2 amazing things. First, they've entirely stopped bringing these cases, okay? they don't like being called racist or having their ATF called racist. So they're like, okay, we're out of this business, basically. So that's great. And secondly, they have dismissed pretty much all of the mandatory minimum drug counts, the things that I told you got those really high penalties. In our pending cases. So the New York Times reported about this development. There was a front page article in the Tribune about this. And as a result of these dismissals, before I said 15 to 25-year mandatory minimum, now our clients have 5-year mandatory minimums. They've got a guideline range for the robbery also, but the judge, it's discretionary. So it's really changed the landscape for our 43 clients who are still pending on these cases. And finally, some of these prosecutorial policy changes led us to be able to get bond motions granted, because we went back in after they dropped those drug charges and we relitigated all the bond issues. So when my clinic first got involved, there were almost 40 clients of these 43 who were in jail. We brought renewed bond motions. Now we've got about 30 clients out on bond also. Thank you. So just to close, I think these victories, to me at least, exemplify some really important lessons for those of us who advocate on behalf of clients of color in this system. So a couple things. First, I think my idea of there is strength in numbers, right? If we stand together against discrimination, we are more powerful and we're more visible. Second, there's strength in statistics. So if we support our discrimination claims with empirical evidence and expert testimony, we can surmount things like the Armstrong standard. And I'm even doing something where I'm trying to distinguish McCleskey. I mean, there are things we can do with the bad law if we try to bring a different focus and try to bring expert testimony. And third, it's not all about attaining victory at the end of the road, If we just focus, I think, on winning or losing, and a lot of people say, well, this will never win, you'll never convince anybody to do this. But if we just focus on that, we lose sight of the power of the fight, right? There is power in the fight. And so sometimes this very process of just collaborating and fighting creatively can create change. And it can open people's eyes to the injustice that we've all just been living with and experiencing, but not really seen. If we present a unified front, we can put a stop to this. We can put a stop to discriminatory law enforcement practices. We can put a stop to discriminatory prosecution. We are all out here trying to win our clients their liberty, but in the course of that, we are also trying to protect their dignity. So every time that we file a motion, every time that we walk into court, we are showing our clients that we believe in them and that we will stand up for them and that we will do everything in our power to win them back their freedom. Thank you.